Buddy, thank you for joining us this Week in America on the Blue Funk Broadcasting Radio Network, website thisweekinamerica.us. Mentioned in the beginning, we're talking about wills on the program today. Really came to light with the Michael Jackson situation. Steve McNair didn't have a will. So many people think, I don't really have that much. Do I really need a will? We want to talk about that in the program today. Back with us is Bruce Steer. Bruce is an elder law and probate attorney. Bruce, first of all, haven't seen you in a while. Welcome back to This Week in America. Great to have you with us.
Thank you, Rick. Good to be with you.
There's so much to talk about, and we're going to start with wills, and then if we have time, get into maybe what we should be doing now and asking our parents if they have wills, if they have power of attorney, that type of thing before a situation arises that it's really too late and we wish we would have known that information. Let's talk about wills. I understand that really most people don't have them, and I remember we were talking before the program, when I was young, married, had a couple of kids, we really didn't have a will. We thought, I guess, we were indestructible, we were going to live forever, and when we were first married, we really didn't have that much. Are those sort of common reasons why people don't have a will?
I think those are some of the reasons. I think that often people who are newly married and have maybe a couple of small children are sometimes the most responsible people about getting a will at that point in their life. But certainly as your life changes, it becomes even more important to have a will. That is one set of examples. Young family, 2 small children, where it's essential to have a will, but it becomes even more essential as you get older.
Well, let's talk about what would have happened to maybe both of us traveling in a plane accident, something like that, or to one of us. If we don't have a will, who determines? The
state of which you are a resident determines. It has a will for you. If you don't have a will and you are the resident of a state with assets in that estate and dependents in that state, the state will determine by its own laws what happens to your property. And one of the things that could happens in many states, is that your inheritance taxes will be considerably higher because you haven't planned to handle that through the will instrument.
And that's interesting you talk about that, because we talk about the will. How about other end-of-life plannings, situations that we need to do? What do we need to do?
Well, the example that you posed to me is a very good one. If you and your wife are on a plane and there's an unfortunate accident and it cannot be ascertained who died first, if you had a will, your will could have provided that under circumstances where it cannot be ascertained who died first, it shall be presumed that I died first and my wife died second. This is important because it avoids you having to open, or your survivors having to open 2 estates and having insurance companies battle back and forth about who died first. Your will takes care of that problem. It just simply says, her will controls, it shall be presumed that I died first under those circumstances. Simple solution to a potentially huge problem. The will also can avoid the kind of questions and difficulties, conflicts that you've seen that have been encountered by the Michael Jackson estate. A will can specifically state who your personal representative, that's the person that handles your affairs, is to be, and who is to have that responsibility in the event of your death. Thirdly, and we'll again use Michael Jackson and your own example about dying in an airplane collision, your will can provide who the guardian for your children will be. And it can even state alternatives. For instance, if the best guy in the world I know to raise kids, my brother, predeceases me, then my second choice would be perhaps my sister or Aunt Martha. So those are the kind of things you can do with it. You can customize what happens to you and the people that are important to you after you die. And that's the beauty of a will.
I want to jump ahead, but I'm going to, because you mentioned something that's interesting. If I did a will in 1997, I can't think I've got a will, I'm all taken care of. How frequently should we go back and revisit a will that we have? Because situations change oftentimes annually.
I think when that last child reaches age of majority, graduates from college and moves on, is a good time to review your will. Another time to review your will is as you approach retirement age. Anytime there are large events in your life that have consequences economically and in terms of your lifestyle, that's the time to review your will.
Let's go back and talk about when you start mentioning a will, some people think complicated, this is going to be very expensive. How complicated is it to do a basic will? How expensive is it to do a basic will?
Well, I can say sitting here right now with the example you first posed, and it's a very good example, a married couple with 2 children, you're on a plane ride, let's say before the plane ride you make a will. That will, which I would call a simple will, where you provide for your wife, everything would go to your wife in the event of your death. In the event of she dies with you or simultaneously, it all goes to the children. That's what we call a simple will. It's a basic will. That's going to run, depending upon your viewer's listening area, anywhere between a low of $350 and a high of $700 for both wills. And it's if you compare the difficulties the Jackson estate is currently having with the ease of having a simple will like that solves a lot of these problems, the cost difference it's phenomenal.
You're listening to This Week in America on the Blue Funk Broadcasting Radio Network. Great to have you with us. Website thisweekinamerica.us. Bruce Steer, attorney Bruce Steer is with us, elder law and probate attorney. Several things came out of Michael Jackson. First of all, in the beginning, after the death, people were saying, we don't know anything about a will. He doesn't have a will. Once you have a will, how do you go about letting people know, in fact, there is a will?
What you do is in most states, what you do is you probate. That is, you record the will at the clerk's office at the county courthouse in the county of the state in which you live. Probating a will does not mean that you engage in a lot of expense in administering the estate. Probating a will is a simple procedure. In most states, it costs between $75 and $250 to probate a will. What that does is spread the will of record, so no one after that fact can ever deny what the will says because it is placed on the public record at the courthouse.
Also out of Michael Jackson comes the story that they read the will and certain family members are saying, no, that's not right. Michael never would have done that. How do we, when we put a will together, make sure we're not going to have these family squabbles, family disputes afterwards? People contesting the will saying, but that's not what Rick would have done in this situation.
Well, it's a very good question. Sometimes you can anticipate those issues and draw a will in such a way that you can just take care of them. But where you can't, where you have unanticipated issues that arise after you die, the fact that you have a will and it's probated means that a court can more easily disseminate what your intentions were. There are deadlines that are imposed. Once you file that will, once you probate it, there are deadlines that begin to run before somebody, and once that deadline is passed, then you can no longer challenge that will. So again, that's the advantage of having a will.
And I would assume in your case and others with competent elder law attorneys, as they're sitting there with their client they're representing as they put a will together, if there are some red flags that come out, you can talk them through the process and maybe clarify some of the situations.
Absolutely. For instance, many people have children who have moved out of the state. They live in a foreign state. That person, if they're going to name them as their personal representative to handle their affairs once they decease, would be required to be bonded because they're coming from a foreign state. You can avoid that issue by appointing a co-personal representative, that's an Indiana resident in our case, to serve with them and avoid quite a bit of a lot of expense by putting that right there in your will.
I think what we're saying, if I'm hearing this, is if you're preparing a will, you're not only really helping yourself to make sure what you've worked for, your assets are taken care of, but helping your loved ones get through a very difficult period. I would assume if you lose a loved one and suddenly you're faced with all these legal issues because you didn't do your due diligence up to this point, it'd be very difficult.
That's correct. You get to customize and control what happens after you decease, as opposed to not having a will, in which case the state has a one-size-fits-all solution for you, and you're going to be stuck with whatever that the state government's law is pertaining to your affairs.
Listening to This Week in America on the Blue Funk Broadcasting Radio Network, website thisweekinamerica.us, talking about wills, what you need to do with elder law and probate attorney Bruce Steer. I read something about a letter of instruction, which basically is you need to let people know not only where the will is, but life insurance, any of your investments, that type of thing. Is that a common problem where maybe there's a will, but scattered in various other parts of the home or even outside the home? You've got to go back and you've got to retrace what the person actually has for the estate.
Yes. First of all, it's a good idea if you make a will, tell your children and the person you appointed as your personal representative, that's the administrator of your affairs, where the will's at. But secondly, a letter of intent is an excellent idea. Letter of intent is it's not a testamentary instrument. It's not like a will. It's just a letter of instructions. Here's where I left stuff. And that's what the letter of intent tells people. Another thing a letter of intent can do is it can tell people how you want your burial and funeral to be conducted, for example. Now, usually, people don't even read the will until after you're in the ground. So, not to be morbid here, but the letter of instruction is something they can read immediately. And it can say, here's how I want my burial and funeral to be conducted. Here's where the will is. So it's a general letter of instruction. And it's a very good idea to have that.
What happens when, and we'll use Indiana as an example, I'm in Indiana preparing a will and we move? Are there changes we have to make to that will when we change states?
Yes, there can be. And most of those changes, the most significant changes, will be in a tax. Is there an inheritance tax in the new state? And how is that inheritance tax determined? So you need to take your will to an attorney in your new place of domicile and residence, show it to him, and ask him, is this will still apply in this state? Very often it will. But sometimes there are inheritance tax differences in other state taxes that impact your estate in the event you die.
A lot of good information there. We've got a couple minutes left on the program. I want to talk about what we need to do now to make sure our parents are covered. And having that discussion is always difficult. How do we go about that discussion, and what should we be asking our parents what they have in order so we can properly take care of them?
Well, the current figures, Rick, on Alzheimer's disease and the symptoms of dementia that it causes are that 50% of us will incur that disease and suffer from it before we die. As many as 67% of us will lose our mind before we lose our life. Those are high figures. I think they're exaggerated figures. But if we could just use those for purposes of our discussion today, let me just say this. It's essential that all of us who are over 40 or own real estate or have children in any of those three events have a power of attorney document appointing some person or persons to handle our affairs if we no longer can. Also, a healthcare representative document that appoints who makes medical decisions for us if we become incapacitated. Those two documents are so inexpensive to make. They don't lead to a lot of legal expense to administer. They're very inexpensive to administer. And once you have those documents, somebody can handle all of your affairs for you, subject to the fact they can only act in your own best interest. But they can handle all of your affairs without ever having to create an expensive, intrusive guardianship. And so that's essential. That's, in many instances, having a power of attorney and a healthcare representative appointed is more important than having a will even.
The way I asked that question assumed the burden would be on the children to ask the parents. Am I looking at that incorrectly? Should the parents be saying, okay, here's what I want and let's get these documents taken care of so I'm taken care of the way I think I should be?
Every person needs a power of attorney and a healthcare power who's over 40 years of age. If you fly to England for a 2-week vacation with your wonderful wife tomorrow morning and you have an accident because you're driving on the wrong side of the road over there and you wind up in a hospital and she's there taking care of you, somebody needs to be back here with legal authority to sign contracts for you, to pay your utility bills, your mortgage, collect your income. Who's that going to? No one has authority to do that unless you appoint a power of attorney. Making a power of attorney and appointing a healthcare representative for each of us is something we do before we become elderly. If you're elderly, it's essential to have. But even if you are over 40, and I can give you innumerable examples. The travel example is the one that immediately comes to mind. Have a power of attorney. Have a healthcare representative. And you don't have to surrender authority to them, but have it in the drawer. Tell them where it's at if something happens to you.
In a practical situation, I assume, and we've got about 30 seconds left, is if you don't plan properly, from an estate standpoint, it could cost the heirs thousands, tens of thousands of dollars?
Yes, attorneys don't make any money off preparing powers of attorney and wills. They make money when you don't do those things, because then you have controversy.
Yes.
You have controversy, and when you have controversy and you have lawyers involved, you have expense.
So it's a lot cheaper to do it in the beginning rather than react to it.
It's very nominal.
Bruce Steer has been our guest, attorney, elder law, and probate attorney, back with us on the program. A lot of great information there. You're listening to This Week in America on the Blue Funk Broadcasting Radio Network. Our website, thisweekinamerica.us.